Hello, my name is Barbara Zeitler. I'm a barrister at Land Chambers.
Hello, my name is Elizabeth Dwomoh. I'm also a barrister at Land Chambers.
And during this bite-sized talk, Elizabeth and I will highlight 5 key property cases that practitioners should be aware of in 2022. Some of the cases we have chosen have appeals pending, and in some of the cases we'll be talking about the appeals have already been determined. And we're talking to you on the 2nd of March 2022. Elizabeth will now talk about Northwood and Fern.
Thank you, Barbara. A document that must be executed by a company must be executed in accordance with Section 44 of the Companies Act 2006. This section allows a document to be executed by affixing the common seal of the company or by signature. A document is validly signed on behalf of a company under Section 44 if the document is signed by 2 authorised signatories or by a director in the presence of a witness who attests to signature. In 2014, Cook and Fern were granted an assured short-hold tenancy by Northwood Solihull Limited, their landlord. They paid a deposit to their landlord, who was required to protect it under the terms of the tenancy deposit scheme established by the Housing Act 2014. As part of the initial requirements, Northwood was also required to comply with Section 213 of the Housing Act 2004. This section placed an obligation on Northwood to give Cook and Fern prescribed information relating to their deposit and information concerning the landlord. The form and content of the prescribed information was mandated by Article 2 of the Housing Tenants and Deposits Prescribed Information Order 2007. Article 2 of the 2007 order was retrospectively amended by the Deregulation Act 2015. The amendment required the landlord to sign a confirmatory certificate, which, amongst other things, attested that the content of the prescribed information was accurate to the best of the landlord's knowledge and belief. The certificate given to Cook and Fern was signed by a sole director of Northwood Solihull Limited. Cook and Fern fell into rent arrears, and Northwood served a notice under Section 8 of the Housing Act 1988 to commence possession proceedings. The notice was signed by a property manager on behalf of Northwood, but rather than recording on the prescribed form that the document was signed by the landlord's agent, the property manager indicated that they signed as the landlord. When Northwood commenced possession proceedings, Cook and Fern defended the claim by arguing that the Section 8 notice was invalid because it was not properly signed or executed by the landlord. Cook and Fern also counterclaimed for a penalty under Section 214 of the Housing Act on the basis that they were not served with valid prescribed information because the confirmatory certificate was not executed by Northwood in accordance with Section 44 of the Companies Act. At first instance, and on the first appeal to the High Court, it was held that an agent could sign a Section 8 notice on behalf of their landlord. There was no requirement for a company to execute a Section 8 notice in accordance with Section 44 by the Housing Act. The Court of Appeal upheld this finding on appeal by Cook and Fern. It was further determined at first instance and during the first appeal that the confirmatory certificate was required to be executed in accordance with Section 44 of the Companies Act. The statute required the certificate to be signed by a landlord, and that was the only way in which a company, as a corporate landlord, could execute a document. It was for the High Court simply a binary matter, but the Court of Appeal disagreed. In allowing the landlord's cross-appeal on this point, the Court of Appeal found that Article 2.3 of the 2007 order permitted the landlord to be read as including a person acting on behalf of the landlord. The confirmatory certificate had been signed by a director who had signed on behalf of the landlord. This is clearly a decision that will be welcomed by corporate landlords and their managing agents, as it simplifies the statutory requirements for serving Section 8 notices and confirmatory certificates. Barbara will now speak to you about Alberti and Cadigan Holdings Limited.
So this is a valuation dispute in the context of enfranchisement under the Leasehold Reform Act 1967. And the case concerns the price to be paid for the freehold of the house where improvements to the property have been carried out. The applicant leaseholder argued for a value of 2.6 million, the freeholder for a value of 11 million. And I will explain a lot later why there is such a discrepancy in the proposed valuations. The case was decided by the upper tribunal in 2021 in favour of the applicant leaseholder. The Court of Appeal heard the case about a month ago on the 8th of February 2022. And this is a case that has a significant effect on the price payable for the freehold of the property. It's quite important in this case to be aware of the background to the valuation dispute. The case relates to a property at number 10 Cheney Walk in Chelsea. That property was built as a single house. By 1971, the building had been converted into 5 flats. And in that year, the cartoonist Gerald Scarfe took a long lease of the building. During the 1970s, Gerald Scarfe restored the building to a single house. He removed internal partitions, took out redundant bathrooms and kitchens, and made various improvements. In May 2019, Mr. Scarfe gave notice to the landlord, namely Cadigan Holdings, of his intention to purchase the freehold. In August 2019, Mrs. Alberti purchased the remains of the lease from Gerald Scarfe and pursued the acquisition of the freehold. Planning policy and planning regulations form an important part of the background to this case. At the time, the house was being reconverted into a single house by Gerald Scarfe. The conversion works were lawful and planning permission was not required. Subsequently, planning policy and regulations changed. By 2019, the planning authority favoured the retention of flats. Planning permission would have been required for works to reconvert the property into a house. At tribunal stage, the parties agreed that at the time the valuation of the property took place, planning permission for the reconversion into a house would not have been granted for any similar property. Under the legislation, the price is to be determined on the basis of a hypothetical sale of the freehold, subject to the lease on certain specified assumptions. And for present purposes, the legislation requires any improvements by the tenant to be disregarded in the valuation. Parties were agreed that the reconversion works carried out in the 1970s were improvements. However, they disagreed what effect the exclusion of the improvements had on the valuation of the property. That is to say, whether the house had to be valued only as 5 flats, not as a single house. Mrs. Alberti argued that the tribunal had to have in mind that on the valuation date, it would have been unlawful to use the property as a single house and could be used only as 5 flats. Cadigan Holdings unsurprisingly disagreed and argued that there was no such requirement and that what had to be valued was a house. The upper tribunal found in favour of Mrs. Alberti. The assumption to use when valuing the property was that the works had not been done, and what was being valued was the property as if it consisted of 5 flats with limited development potential. Clearly, this decision has a significant effect on the price payable for the freehold of the property, and we wait to see how the Court of Appeal decides the valuation issue. Now, Elizabeth will talk about First Port Property and Settlers Court.
First Port Property Services Limited and Settlers Court Right to Manage Company Limited and others was a leapfrog appeal to the Supreme Court. Judgment was delivered on the 12th of January 2022, and it is, in my opinion, a landmark ruling in the right to manage arena. Why is it a landmark case? Quite simply because it has overturned the problematic case of Gala Unity Limited and Ariadne Road Right to Manage Company Limited. The statutory right to manage conferred by Chapter 1 of Part 2 of the Common Hold and Leasehold Reform Act of 2002 gives long leaseholders the right to acquire from the freeholder the right to manage their block through a company known as a right to manage company. In Gala Unity, the Court of Appeal held that the right to manage company that acquired the right to manage a block within a wider multi-block estate also acquired the right to manage common appurtenant estate facilities. The problem with this decision was that on a multi-block estates, common estate facilities serve not only lessees of the flats of the block acquired, but other flats in blocks that were not managed by the right to manage company. Practical difficulties often arose in relation to whether the freeholder or their managing agent or the right to manage company was responsible for the management of the wider estate facilities and recouping the cost of the same through the service charge provisions of lessees of the estate, especially in circumstances where a direct contractual obligation for payment did not exist. First port concerned a multi-block estate situated on Virginia Keys Estate, London. In November 2014, the respondent, Settlers Court Right to Manage Company Limited, acquired the right to manage Settlers Court, which was a block within the estate. The appellant management company, First Port Property Services Limited, was originally under the tripartite leases for Settlers Court, responsible for managing and providing the wider estate facilities. When Settlers Court Right to Manage Company acquired the right to manage Settlers Court, a dispute arose as to whether First Port or Settlers Court Right to Manage Company was responsible for providing the wider estate services and collecting service charges from all the lessees on the estate. The Supreme Court agreed with submissions made on behalf of First Port Property Services that the statutory right to manage under the Common Hold and Leasehold Reform Act did not confer an extended right on the right to manage company to share management responsibilities for the wider estate facilities with either the freeholder or their managing agent. When those wider estate facilities were used in common by lessees of multiple blocks within the development, the right acquired was limited solely to management of the block acquired and appurtenant facilities used exclusively for the benefit of the occupants within that block. The Supreme Court commented that if the extension of the right to manage companies' right as determined in Gala Unity really was to work, it would create problems that were so great as to amount to an absurdity. Barbara now will discuss the case of Fern and All and Tate Gallery, the curtain case.
Yes, I think of it as the net curtain case, because at first instance in this case, the judge held that one of the steps the complainants could take to protect their privacy was to install net curtains. Net curtains, of course, don't go very well with the modernist style of the building where the complainants live, and which was designed by the architectural firm of one of the greatest architects of the second half of the 20th century and the beginning of the 21st century, the late Richard Rogers. In essence, this case is of course not about net curtains, it is about competing rights and how to balance them. This case was heard by the Supreme Court in early December 2021, and we await the decision. A bit of background to this case: the appellants own flats in a luxury block known as Neo Bankside. That block is adjacent to Tate Modern. The building is mainly constructed of steel and glass, and the windows of the properties are floor-to-ceiling windows. At roughly the same time as the flats were being built, an extension to Tate Modern was constructed. This is known as the Blavatnik building. The Blavatnik building is 10 stories high and has a 360-degree viewing platform which is open to the public. The viewing platform permits visitors of the Tate to look into the appellant's flats. The owners of the flats complained being subject to scrutiny by visitors to Tate Modern. The gallery took steps to reduce the intrusions, but the appellants brought proceedings seeking an injunction on viewing from part of the viewing gallery on the basis of Article 8 of the European Convention on Human Rights and in common law nuisance. The appellants were unsuccessful at both first instance and the Court of Appeal. At first instance, the claim in privacy under Article 8 of the European Convention on Human Rights was dismissed because it was held that the Tate was not exercising functions of a public nature within the meaning of the Human Rights Act 1998. The nuisance claim was dismissed because the owners of the flats could take protective measures, such as installing net curtains. At Court of Appeal level, the appeal related solely to the claim in private nuisance. The Court of Appeal rejected the appeal, but for different reasons from the first instance decision, deciding that overlooking does not fall within the scope of common law nuisance, nor was there any sound reason to extend the common law tort of nuisance to overlooking in light of Article 8. Now, when this matter went up to the Supreme Court was asked to consider whether, first, a private nuisance is capable of providing a remedy against viewing from neighbouring land, and second, whether public viewing from the Tate's platform infringes Article 8 of the European Convention on Human Rights. And what I think will be quite interesting to look out for when the Supreme Court decision comes out is to see how some of the arguments made at the hearing are going to be decided by the court. For example, the argument made in favour of the flat owners to the effect that if the Court of Appeal was right, the flat owners had no legal remedy if the Tate started using the platform as a nightclub, playing loud music, or as a place for having a barbecue emitting lots of smoke, or even as a rubbish storage area. It was also argued on behalf of the appellants that the effect of the Court of Appeal's ruling that the Tate could open the platform 24 hours a day, and it could provide every visitor to the viewing gallery with binoculars. And it'll also be interesting to see what the Supreme Court will say in relation to arguments made in favour of the Tate, which was that the appellants were seeking to impose a radical change to the Court of Nuisance, not an incremental change. And it will be interesting to see whether the Supreme Court agrees with the lower court's decision that the law of private nuisance does not apply to the kind of conduct relied upon by the appellants, namely overlooking. And it'll also be interesting to see, I think, how the Supreme Court will deal with the competing rights of, on the one hand, property owners who want to reside in properties with floor-to-ceiling windows, and on the other hand, visitors to an art gallery that want to enjoy views over one of the world's major cities. Finally, Elizabeth will talk about Croydon and Colonga.
The Supreme Court heard the appeal in Croydon on the Borough Council and Colonga at the beginning of the year, on the 12th of January 2022. The judgment is still pending, and in my opinion, it's going to be an important decision, especially for local authorities, because of the prevalence of these types of secure tenancies, many of which may not have forfeiture provisions within the agreements. The case centred around flexible secure tenancies, which is a type of secure tenancy granted by local authorities for a fixed term of a minimum of 2 years under the Housing Act 1985. By virtue of Section 107D of the Housing Act, the landlord can terminate a flexible secure tenancy on the expiry of the fixed term by relying upon the mandatory ground for possession. Under Section 82(1) of the Housing Act 1985, a secure tenancy, which is either a weekly or a periodic tenancy, or a tenancy for a term certain but subject to termination by the landlord, can only be terminated in accordance with one of the 3 methods set out in Section 82(1)(a), namely, by obtaining a possession order and executing the same, by obtaining a demotion order, or, in the case of a tenancy for a term certain, but with a provision for re-entry or forfeiture, obtaining an order for the termination of fixed term tenancy and its replacement with periodic tenancy. In Colonga, Croydon Council had granted Ms. Colonga a flexible tenancy for a fixed term of 5 years. The council found that she'd been guilty of antisocial behaviour and sought to terminate her tenancy during the fixed term by relying upon Ground 2 of Schedule 2 of the Housing Act 1985. Ms. Colonga accepted that her tenancy was a tenancy for a term certain, yet she contended that the local authority was unable to rely upon any of the avenues of possession set out in Section 82(1)(a) of the Housing Act because her tenancy agreement did not contain an express forfeiture clause permitting her landlord to terminate her tenancy during the fixed term. In the circumstances, she argued that Croydon Council would have to wait until the end of a 5-year fixed term period to rely on Section 107D for possession. The High Court found for Ms. Colonga and dismissed the possession claim. Croydon Council appealed, but the appeal was dismissed by the Court of Appeal, who found that Ms. Colonga's tenancy agreement did not contain the requisite forfeiture clause. The Court of Appeal held that a fixed term secure tenancy could only be terminated during the fixed term if the tenancy agreement contained a forfeiture clause. The local authority subsequently obtained an order for termination under Section 82(1)(a)(c) of the Housing Act 1985. Now, unless the Supreme Court overturned the Court of Appeal's decision, as matters stand, greater security of tenure will now be conferred on flexible secure tenants during the course of their fixed term period. Watch out for that decision.
And thank you very much for listening to us. That is the end of our presentation, which we hope you found useful. Goodbye.
Goodbye. Thank you.